the General Data Protection Regulation, or GDPR, and what to expect when the law takes effect in 2018 webcast. So the GDPR is what a lot of people in America and in major countries right now, including China, are wondering, how am I going to be touched by this new regulations they have in Europe regarding privacy? And a lot of lawyers from all countries, including, of course, Europe, are trying to advise their client about the effect of GDPR on their clients' businesses. Because, in fact, the world has changed in the last 20 years. Everything is electronic now. You cannot have any product or campaign that doesn't have a website or a Facebook page. And GDPR became, for the first time, an international law by the fact that anybody dealing with the EU selling services or product into the EU via website or not, you can have just a brick and mortar shop over there, are GDPR, must be GDPR compliant. So with that, I would say, I always want to start when I talk about GDPR with what I call the little shop of horrors. I get people calling and saying, am I going to have to dump all my marketing campaign? Do I shut down anything on my Facebook page? And so on. Well, the basics that we're going to review today turns around consent. Consent is what the European watchdog are going to look at after. So your clients need to be very careful about the way they gathered those gazillions list of emails and names, and how they keep even their customers, their own customers, on file if that consent has been given long time ago, and we're going to define how long is long. But you also have a lot of other things that you should do and should not do regarding your client's activities. Beside consent, clients should be very aware about the quality of the data that they have, and we're going to talk about that. Old email address, old physical address or phone numbers. Well, basically, the GDPR says, okay, given that you get the proper consent, keep that data not too long in your files, just enough to do what the client consented for, and make sure the data is accurate. So that's the kind of information that your client must have right away when they discuss GDPR. Besides this, if they export the data to the US, well, of course, it's a no-no without the proper foundation to do that export. The problem most of the time is that people don't even know that just looking at their screen here in the US and having the servers and the data over there in Europe is an export. They think that if the server is in Europe and the data is hosted over there, I'm fine. No, if you can see the data here, and if you can look at it and use it and send emails from here with the data, it doesn't matter where the data resides, in the EU or not. The data that I'm talking about here is, of course, the personal data of users in the EU, what we call PII. And the personal information that we have already in the US under different statutes in California, in other states, sometimes it's called PI, or personal information, or personally identifiable information. In the EU, the personally identifiable information is anything, really anything, that can let you identify or locate a client. It could be as little as IP address, or a phone number, or an email address. So if you bought a listing and you have 5,000 names or 50,000 names and email address, beware of the GDPR. You may not have the proper consent because you bought that listing. So you don't know if the consent has been given to the people who sold you the listing. Now, what's in it for American lawyers, my peers? I'm a French lawyer and I work in the US and I work a lot with lawyers to advise their clients. Basically, besides the marketing aspect of your talent and services, when you bring a client and it asks you about GDPR and you put in a few billable hours, it is very important that the client feels that his local lawyer, his US lawyer, no matter which bar you're a member of, California, Kentucky, New York, Massachusetts, you be GDPR aware because of your duty of competence. So, of course, when a client asks you a few pointed questions, you may come back to the client, you check for yourself, call other lawyers. But in general, you must know the basics and a little bit more so that your client are advised properly. And this is the purpose of the CLE. I mean, you know that you have to do a certain number of hours, varies with different states, but the CLE brings you that update on your knowledge of the law in general from your state, federal law, and now GDPR. The first thing is the size of your company or client. Doesn't matter. You can be a solo lawyer with a huge company or a very large law firm with a small client, as long as they have a footprint in the European Union. They are going to ask you something, or they should ask you something about GDPR. If they sell some jeans, some clothes, some sunglasses, some watches, some electronics to the EU via their website, or if they have any activity over there, like, you know, they franchise, so they have some shops, even though the shops are not run by themselves under franchise. If they send some merchandise over there, if they grab some information from the franchisor, franchisee, if they have addresses of clients, or of course credit card, bank information, that is GDPR. And this is not limited to one-stop transaction where someone just goes on that website of your client, buys something, and you never hear about, and that's it, you're done. No, your client has a duty to clean up the database regularly so that information that was given at that time doesn't remain on the server forever. And of course, let's talk about money. And money your client may have to pay if they don't follow your advice. And of course, if you don't give the right advice, we can talk about liabilities. The client knows, because it's been written everywhere, that they can be fined by any authorities or watchdog in the EU up to 2% or 4% of their global turnover. That means if they breach major EU regulations such as GDPR, it may impact severely on their bottom line. And I want to say here that I haven't heard or read a lot about the 28 European watchdogs and the way the fines would apply if you get several of them to fine your client. Well, basically, in case of a problem in, let's say, in Germany, and the major impact on customers would be in Germany, then there is a duty to alert the German authority, and it's 72 hours, I will see later, and that German authority becomes the leader. But if they also have clients in Belgium, in France, in Italy, in the UK, well, at the end of the day, after the German authority has determined that there has been a non-compliance of some kind and fined in Germany your client, the other authorities might fine as well your client, because the non-compliance would be in France, in Belgium, and so on. So you can end up with several, and 28 authorities fining your client. It is something that is very important, because most of the time people think of, you know, $100,000 or $200,000 fine and one shot from one of the authority. It's not the case, and the fact that the GDPR comes from the directive of 1995, the European Directive of 1995, shows that indeed companies like Facebook, Microsoft, and others, and of course Google, have been fined in different countries at the same time for the same infraction. So it is important to note then that those fees are pretty high, but they can also be multiplied by the number of authorities that consider your client has been exposed to a non-compliance. So what are we going to do? We're going to look at two main aspects of the GDPR. In the first hour, we're going to see what is the impact of GDPR on the use of the information, the personal information of the EU subject or data subject. And we're going to call big data anyone that uses profiling or that uses massive amount of information to try to define the habits, the taste, the preferences of a European subject. We're going to see what basically your client expects from his lawyer. Is it GDPR ready or GDPR compliant? It is GDPR compliant that you want, because if it's just GDPR ready, I can say that I'm ready to run the next Olympics or the next bike race, the Tour de France. I'm ready. I bike around my city. I'm ready. Yeah, maybe ready, but I won't be compliant in terms of age, in terms of shape, in terms of all the things. So being ready doesn't mean really that you're compliant. It means that, well, you heard about what you need to do. You're ready to do it, but have you really done your homework and your due diligence? That's what we're going to see. And GDPR is not really, for European lawyers at least, as new as people think here. Here it came last year mostly, and people start to write a lot, and the major media have not yet talked about it. I haven't seen it on CNN, Fox, or whatever, MSNBC and so on. There has been nothing yet about that because we are not close to May 25th and it's not news. It's coming, yeah, that's for sure. But GDPR has been, in fact, in place for 70–80% since 1995. There's a few things that are very new, like those hefty fines and other things that we're going to talk about. But for a European lawyer, there is a huge amount of case law that arose from the practice of the 1995 directives on privacy, and that will be applied by the same authorities, basically, to the GDPR. So anytime I have to interpret an article from the GDPR, I look at the body of decisions from the European Court of Justice, and I then, have the right ground to interpret for my client a question that was not very clear in the text. There are 99 articles on the GDPR, so it's a pretty big, a lot of room for interpretation, and a lot of those articles are there to be friendly because they're not really clear and they need guidance. So with that, we are going to see at the end of the first hour the 6th step that you have to bring your client to become compliant. Then the 2nd hour, we're going to talk about data protection officer. It is not mandatory for the majority of your clients, and we'll see what is the level of the law as to hire a data protection officer. The data protection officer basically think privacy officer, and it is mandatory when you have big treatment, think Facebook, Google, etc. But when it's not a massive amount of data, when it's just here and there, you don't need a data protection officer. Although the European authorities recommend that on the book you get one, and we'll see why. We'll talk about what is the effect of GDPR on marketing companies on the internet, what we call advertising technology companies and marketing technology companies. And there's a lot of those. And we're also going to see for the mid-market, for lawyers the small and medium-sized enterprises, the startups, and I work with a lot with Silicon Valley because I'm based in California. So spend my time between Silicon Beach in LA and Silicon Valley in the Bay Area. Because privacy by design and privacy by default are the main, I would say, principles for startup to follow to be GDPR compliant. And as most small companies and startups have usually an app on either Android and you name it, and Apple, of course, that app reaches out to Europe, it must be considered at the very early stage of the development of their product or services. And we'll conclude with what I call the day after. Well, it happens to be that May 25th is a Friday. So on May 25th, probably nothing's going to really happen to your client. They're not going to receive a request letter from any authority. And I would say it's going to be Happy Friday. But consider the following week. Those authorities already have lists. They say that it is not true, but it is a fact that if you are working for the German, the French, the Belgian authorities, the UK, CIO, you're probably ready to send out requests to large companies, just as, do you have a DPO? Because we didn't see you sending us the name of your DPO, Data Protection Officer. And here it goes. On Monday, after the May 25th deadline has expired, they are going to receive that demand, and they won't be able to say, oh yeah, my DPO is Bob whatever. They're going to say, no, we don't, and that is already a problem. But with this, we're going then to introduce the different aspects of GDPR on big data and the use of personal information. And the first thing that I mentioned earlier is consent. Consent and consent. That is the main rule of GDPR. We have exceptions, of course, but your client better understand that the years of opt-out, where we grab everything we can, and if a client is not happy, just opt out. But we keep the rest of it. It's over. You don't fish anymore with a grenade or a large net. Now you're going to have to learn how to fish line like a flying, and you're going to have to tell your client that this is a total turnaround because the consent is not just a check box, a box that you have on the screen and you check, and you just have to press OK. The box has to be unchecked, and also the language around that check mark is important. And that language has to be very clear. It's not going to be, yes, I consent, yeah, you can use my data and forget about it. No, you have to explain also that what you're going to do with that data that you collect. Are you going to use it just for yourself? Are you going to share it with outside partners or third parties? Are you going to sell it to people that would like to know about your client, and that the job is to aggregate data from all different companies and start building profile of EU users? So this is very important, that the consent that you're going to have to fish for is obtained very clearly from the users of your client. And that consent has to be collected worldwide. So if you have different websites, for your client has different websites in different countries, in different languages, well, you will have to make sure that your client understand that the website that sells stuff in Asia has to be GDPR compliant as to collecting the information. Even if you are selling, or your client is selling the product or services in Asia. Because you can have some people in Asia, European people who travel and go to that website over there and sign off on a proposal, service, or acquiring a product from that website. You have expatriates like me, actually, in the States, that can use a European website when I'm in France, but when I'm in the States, although I'm a resident here, I'm still European, and I am, if I am in one of the database here, I could claim that because my law office is in France, I don't want all my data, my personal data, to remain more than necessary in such and such database. It's not, and I repeat, it is not the citizenship or the residence that is at stake here. It is the data that resides in Europe, not the data subject, not the person, not the user. If you are using any personal information from Europe that exists because it is in Europe, then GDPR applies. Even if the owner of that information is traveling right now and for the next years around the world, his data arose from a collection in Europe. And I'm going to give you an example. You are an American citizen traveling to Spain with your family on vacation. You make a reservation to have your car ready in Madrid. You land in Madrid, you go to the Hertz or Avis or any other brand that you prefer to rent a car from, and at the desk, your car is ready. They give you the key because they have all that information from you, driver's license number, everything. You entered it on the website here in the US. The company has its headquarters in the US. Your data is in Madrid at that moment. And at that very moment, although you're American, although you're absolutely not a resident over there, the Madrid desk of Hertz or Avis must be GDPR compliant because they are holding some data in Europe about an individual. And if I want to be complete, I would say the individual could be of any nationality, as long as the data has been collected and used in Europe. It can be collected outside if it's used in Europe, or it can be collected in Europe and used outside. It doesn't matter. If there is a point of contact of that data with the EU, it's GDPR that applies for that data. So with that, we can say that the consent that you obtain from the client is something that you have to be very careful about in the manner you collect it. As I said before, there is no pre-ticked boxes, and you cannot find a way to kind of send some fog around what you're going to do with the data. It's also important that when they click, they should not feel under the gun, obligated to say yes, 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 because they want to use your service or your app, your application. They have to click, yes, I consent for you to use my data voluntarily after knowing that you may use that data a little bit longer than necessary, and maybe you're going to share it with big data companies and all that. Where do you put that information? In the privacy policy, of course. But here is the thing. The link to the privacy policy has to be very clearly exposed next to that box where they're going to check yes. It cannot be at the bottom of the page. It cannot be in very small font 6 somewhere in the corner of the page. It cannot be written in very pale gray on the page on a white background. It has to be right there on the pop-up, if you have a pop-up on the web page where you have that little check mark, then you have privacy policy. And they, of course, must be able to click on the privacy policy and read whatever they need to learn, like it was always before. But the language here is no longer those legalese and we lawyer way too often put there. It has to be very clear language. It has to be absolutely transparent to the user that you are going to use that data that they're going to put in the form, and you're going to use and share that data with third parties. And not only that, if you're selling that data to a big data analytics firm, let's say in New York, and you sell it globally with the name of the people or their email address or anything that can identify them. You're going to have to tell your users in your privacy policy the name of the company that is going to use that data as a third party. So it's not just like, well, we're going to grab your data and some partner is going to use it. No, it's going to be, well, we're going to grab your data for analytics, for commercial purposes, for whatever, with company X, and then the address or the city and USA or India or whatever is the country, so that they know where the data is going to land at the end of the day. And it's because they have, after they consent, they have a right to withdraw that consent, and they have the right to have you delete their data from your computers, but also from the third-party computers. So if you sold that data a year ago or 2 years ago, and they don't know where you sold it, well, then the GDPR would not really apply, because it would be so simple to just tell them, well, I can't do because I don't remember where it is now. And no, so they can verify, because they know that you send it to company X, big data analytics company in New York, and then they can write to that company and say, have you been told or requested to delete my data? Because 2 months ago, I said that I don't want that data to continue to be in the hands of such company, your client. And if they say, well, no, well, then you start to be in trouble with your client's compliance with GDPR. And this is something that, your client need to do. When you click on that form, after you have the privacy policy right up front and center, and after you inform them of all the whereabouts of the data you're about to collect on them, and they agree, then you have to protect your client, and it has to be very, very sure that they're going to have a record of that click. So there's a lot of ways to do it. Of course, computers are here for that, but the most important thing is that your client gets to register the click in a way, in a database, or with a check mark somewhere, even sometimes with just an email that is sent to yourself or to your own client, saying I consent, or I consenting on such date, an automated email from the website actually where you consent. There's many ways to do that, but basically you have to keep a clear record of that consent, because if you get some people going after you, your client, for using that data without their consent, and you can not prove, how it has been collected, then your client will be in trouble. And this is because consent is also given not always on a website. So let's say you go to a convention, or you go to a training, and you meet people over there, and they give you their business card, and you enter that data in your computer. Is it consent? No. They just gave you a business card because they wanted you to know who they are, and you wanted in the same way to show them who you are. So exchange of business card is no consent to receive email every other day saying, hey, look how beautiful I am, and look what I'm selling to you, and all that. Consent is not exchanging business cards. It's not even necessarily inviting somebody for lunch or dinner, or a client or a prospect, and having a 3-hour meal in Paris with all the hula hoops and what we have and good food. That's not consent to anything. You don't feel, the client doesn't need to get your email for the next 3 or 4 months to attend your seminars, or get to go to your conferences, or buy your products or your services just because you had a fantastic time in Paris. That's no consent. So there is no website here, but you would need to take that business card, and your client would have to write to that prospect and say, I really enjoyed your company that day in Paris, and would you be interested in whatsoever? Now you get a consent through the mail saying, yeah, of course, or yeah, why not? And if you think that you would eventually exchange the information you used to work with, then you also say, I'm usually working with company X in New York that does big data analytics and all that for us, and I wanted you to let me know if you would be okay, but we share that data with them. That is what is consent. Okay. At the same time, as I explained earlier very quickly, your users are able to withdraw the consent that they give you at any time. They give you consent, maybe the next minute they regret, they withdraw. Or a month later, they don't even remember how they did consent to your services, and they don't remember your website address. So it must be very easy and transparent at the time they consent that they can withdraw their consent. Something as simple as a button that say add check, it's a switch button, yes, no, and you click and the button moves to the right, gets green and say yes, or goes back to no on the left and gets red. That is what actually today companies in the startup, I would say, business use most, because it leaves a trace on that profile on the website. It also leaves a trace in the database, but it's so easy for the client to go back to the website. And if you've never been on that website, has your business card, chances are that there is a website on the business card. They can always go over there. You don't have to call the client every 2 days and say, do you still give me the consent? Do you want to withdraw? Of course not. But it has to be very clear for the client or the user, that he can withdraw his consent at any time. And that will, in fact, facilitate him to give you the consent. Now, if he's bombarded by, one email an hour, chances are he's going to withdraw the consent. But if you are, using the email wisely, or your client is using the email wisely, he may not withdraw. In every email that he gets from you, here again, you should let them know that they can withdraw their consent. You're just, in the state, you have the same, the CAN spam law, and you have to let people know that they can withdraw their name from your list. Well, it's about the same thing here about withdrawing the consent. It is also important that you keep the terms and conditions, the different terms of the product or service you're selling separate from the consent and the privacy policy. The reason is they must give the consent to use their personal data independently from your terms of sale, your client terms of sale. That consent has its own life. It's just about their data, their phone number, their address, whatever, their email. And it should not be linked in any way to acquiring or buying a product or buying a service. Those are two different things. If you are selling stuff, products, services, even as a lawyer, you're selling your services, that's one activity. And because of that activity, you are going to reach out to people that are going to give you their personal information, name, address, etc. Maybe the name of their wife or husband, maybe the name of their kids. So you have to be very careful here. Your client needs to know that selling a product or a service is one thing. Getting through that service a lot of information about somebody is another thing. They are very separate. So you can condition obtaining a service or a product to consenting to privacy information or private. And whenever you have, or your client has made some changes to the conditions of the original consent, it has to inform the person, the users, that those conditions have changed. You receive quite often, I guess, those Google email telling you we've changed our terms and conditions. And my guess, even as a lawyer, is that you didn't spend much time reading them, the new ones, thinking, well, I can read it later, I can go on their website, it's going to be updated. Well, it's about the same. It's just that you would have to let your client know that whenever the initial conditions that or initial surroundings of that consent have changed, then the users must be informed and have a possibility to withdraw their consent. This is what I call the little shop of horror of the GDPR, because we're not used to that here in the States, where it was until now Everybody opts in by default, and those who are not really happy about it, well, they can always opt out. A minority. But let's work with a vast majority who doesn't even know that we opted them in. So here it's totally the other way. Is in fact what the legislator in Europe want is that you get quality database, that you get clients' consent, so that when you send them information, they will willfully accept your email and that information, and maybe buy something else from you. And they don't want those huge database of people that never consented to receive information other than the original service. And when they surf the web, they get all those pop-ups on the right side about hunting, about jogging, about all those different activities that were involved at some point in their life when they were buying or acquiring something on Amazon or other websites. And they ended up with their name and preferences in those big data analytics, who were then selling it to other companies who were eager to know what your clients or what your client's client want to do on weekends or like to wear as a sportswear, etc., etc. This is what really has changed. Fortunately, or not, you'll decide. Lobbyists in Europe for major companies in the US have tried over the last 5-6 years to influence the decision makers at the EU Commission, who were preparing the GDPR, and later the Parliament, which sits in Strasbourg in France, on the west of France, near the German border. They wanted to tame down the consent issue, so that their client can still continue market their services and products, or if their client were a big data analytics company, continue to live and exist. Because if you have just voluntary explicit consent, then there is no much you can do for the profiling of people out there on the web. So they have two exceptions. There's more, but the main two exceptions that your client is going to be concerned with. First of all, if there is a contract, employment contract or performance contract, if there is a contract involved and you need that information, if you are selling jeans over the web and you get the credit card information because otherwise you won't ship the jeans, you don't need the client consent for you to use their name, address to get that jeans necessarily. Now, of course, remember, if you're going to have some kind of usage of that name and address for other purposes, back to consent. But if it's just a one-shot, I sell some electronics, some clothes, whatever, to European consumers, and I need their info to ship it, no problem, no consent. That's the first exception of Article 6(1)(a) of the GDPR. And you have the material again. You can look at the slides that you're looking at right now later on and refer to it and go to the web and check GDPR Article 6(1)(a). And the other one is 6(1)(f). Of course, between A and F, there's other stuff that I don't want to bother you today with, like public service and all kind of stuff. So, you don't need consent when you go to a public website to register for documents whatsoever and so on. But you need to see very, very carefully the exception of legitimate interests, because it has been viewed as the exception to consent by the majority of the people who write blogs on the web about GDPR, because in fact it comes out from lobbyists that in Brussels and Strasbourg tried to tame the GDPR to the advantage of the companies that have to sell anything in Europe. So the rule that would say the European authorities have set is consent. And in very, very narrow exceptions, the consent can be avoided. And I repeat, it's like the narrowly tailored exception of the First Amendment to your Constitution. The narrowly tailored concept here applies to anything that you would consider a legitimate interest of your client's company. And if your client's company comes to you and say, look, I'm in business, so it is my legitimate interest to market my product, isn't it? Yeah, that's true. And I'm going to say, if your client say, look, isn't it my legitimate interest as a businessman to send out information to people via email to let them know that I exist? Because if they don't, they're never going to see my products or my services. They're never going to buy, and I'm going to die. I'm going to shut down my business. So isn't it? Yes, yes, yes. Absolutely yes. And the European Court of Justice has had occasions to define under the 1995 directive what could be the legitimate interest or activities that would allow a company to reach out to people via email. And we call that WP29, I'm sorry, the Working Party Article 29 of the Directive of 1995, but we are between lawyers, so we can say that, in fact, it's the chief or the one of each local or national authority about privacy, what we call as the data protection authorities. In each country, there is one body, one agency, like you have the FTC or the SEC in matter of finance. Well, we have one. In France, it's the CNIL, C-N-I-L, and the CIO in the UK, etc. And those people meet regularly. I send one guy over there regularly in Brussels, and they are called the Working Party, and they were set to help the directive of 1995 to help national governments to apply that directive into their national laws, and they therefore were equipped with standing out the good word and saying how they interpreted the directive of 1995 and all that. Now here you have a little difference because it's a regulation. Regulation means immediate application into all 28 national laws. It doesn't need to be transposed locally by more laws. It can. France is actually, so I've read that, preparing and submitting to the vote to the representatives at the Chamber and the Senate to have their own implementation of GDPR. It just cannot be less than what GDPR expects the country to do, but it can be more. If the GDPR say it's 72 hours for a data breach, you have to tell the authority about that breach. France can say, no, it's 26 seconds, whatever. The sky's the limit, as long as it's not 72 hours and 1 second. So basically, 28 countries immediately on May 25th going to apply GDPR. And if they want to get more stringent and add to it, they can. National law can do that. And by the way, you will have to monitor through the next few years the countries where your client operates to make sure that there is not a new local law, a national law, like California or New York, if it were in our federal system here, that goes the extra mile. Because you may tell your client, oh, you're okay, you can sleep good. You're 100% GDPR compliant now. Well, yeah, but what about Germany? What about France or Italy just voting a new law that changes the delay to report a breach? Or they just say, well, now the consent has to be written in blood or whatever. Yeah, those possibilities exist that the country, each national of the 28 country, can change the GDPR into something more stringent. And the main thing to remember is the GDPR as it stands is all about getting the consent to use private information. However, those two exceptions are, one, a contract, two, legitimate interest or purpose. Now, the legitimate interests, as I said, direct mail, direct marketing, is very similar to the 1995 Article 7. So I'm personally, as a French lawyer and member of the EU bar, very familiar with Article 7. So it's not new, and I said earlier that the European Court of Justice had several times, the occasion to define what those legitimate interests were and included at some point direct marketing. But, yeah, there is a but. But the recital, and there's 180 plus recital, 187 if I remember, recitals to the GDPR that tune the GDPR. Each recital is not the law, but it helps interpreting the law, and the judges in the EU are following those recitals very closely when it comes to interpret a directive or a national law. So we have here an occasion in the recital 47 to try to analyze or try to imagine what that huge exception can be for our client. It's very important that your client understands that although there is an exception for legitimate purposes, it's not free for all, and forget about consent, because anybody then has a business and would say, look, I don't need consent. It's a business. So why would I bother with consent? It's legitimate for me to do business, to send marketing, and to grab all the 300 million customers in Europe with one big email. It's my survival. It's not. It's not, because there is, like you have in your constitutional law, a balancing test here between the interest of your client on one hand, interest to conduct his business and to survive and to direct mail people, and the interest of the European subject in not being bothered. It's in the mood of in Europe of not getting so many email every day, and they don't like to get these emails from European companies, but also from worldwide companies. They don't want to be inundated the next morning with thousands of email waiting in their mailbox, and that's legitimate also in the States. More and more people are now turning against all those emails, and that's why most of the kids today prefer to use texting, SMS, or Facebook Messenger, because you don't have anything when you send a text or a messenger. It goes, or you receive one. You don't have any pop-up on the side. That's why they prefer that, because emails are a way, if you use some major email provider, and you also have a website to search. And there's not just one, by the way. There's others. You can then be sure that by using your email, you're going to have words that are acquired by those providers, and those words are going to be analyzed, especially with artificial intelligence, and you're going to, little by little, show your own provider of email and internet service who you are. If I send an email to my grandma telling all about myself and where I am now, I haven't seen her for a year, but here's what I did, and here's what I did, and I'm married, and I'm about to marry, well, someone is looking at it. The big brother is not the government. It's those private companies who are providing you with a tool to explain all that. Some people do that even without email. They go to their website, and they're going to post all their pictures of their friends and their kids and their family, and then they comment on it. Well, same thing. You have computers that analyze all that stuff, and then they profile you. And this is very important to understand, that this activity per se is not a legitimate interest to send out information to those users of which you have a profile, or you accumulated a profile from different big data analytics company. So the Article 7, the recital 47 that goes with Article 6, 1F exception. What does it say? You see here on the screen that they are telling you, the people who wrote GDPR say to your client, well, think about that guy you're about to send an email because you are in business and you have the right to do direct marketing. Think about that guy. When he gave you consent, or had he gave you consent in the course of that business, would he reasonably expect to receive email from you that are unrelated or remotely related to that very first transaction? If you sold a blue jean to someone in Europe and that person didn't consent to anything, as I said before, because it's a contract, right? If you have then its data, would that person reasonably expect to receive in the next 4, 5, 6 weeks, 1 month, 3 months, some offers to have a belt that goes with the jean? Maybe. Reasonably, yeah. But what about receiving some information from you to buy shoes? Well, it's still possible. It's an accessory to a blue jean. It doesn't hold the jean, but it's at the bottom of it. And how about now sending an offer for vacation somewhere in Hawaii? Well, how did you do that? You sell jeans. Well, maybe you sold the data to big data analytics company who end up having profiled the user or your customer who bought some jeans from you as someone who would love to take some vacation, and probably in the islands. So now the guy receives an email from a different company for vacationing in Hawaii. And because he looks at the very bottom, just like the CAN-SPAM Act does here, and he sees how the information about himself has been acquired and how he can remove his consent, he may think that that was not really a reasonable expectation on his part to get 3 or 4 months down the line of buying some jeans, an offer to spend some time in Hawaii. So that is what the recital is telling you. It has to be, on one hand, legitimate activity from your company, legitimate interest, so direct marketing, yes, the Court of Justice say yes, but at the same time, it should be the expectation from the person who receives that offer, that new offer, that email, to agree to the content of that email and to consider that the consent that he originally gave has not been modified in a way, and that you are still in the same line of product, and that is basically what here the purpose of collection means. You have to respect the conditions that let you collect that information, and you cannot go too far away from that when you use the exception of Article 6.1f. And you also have, just like the Supreme Court in the US for your First Amendment and others amendment, give you an additional condition, and here it's the necessary purpose. So you cannot say, well, I'm in business. The European courts say it's okay, direct mail is a legitimate purpose for a business. The client bought some stuff from me, and well, we live in this world, okay, 21st century. So the client should know that if he buys something from me and send me his email and all that, he could reasonably expect that I keep a relationship of some kind and send him some info in the future, and even check that box and say, yeah, keep me informed. So now I'm sending him something directly, or one of my partners send me an offer to go to Hawaii on vacation. And is it really necessary for me to send him that email without obtaining a consent first? Is it really necessary to my business to use that form of communication? If I could pick up the phone, maybe that's a better mean of communication. If I could invite the guy for lunch, maybe that's another mean of communication. So you have to tell your client that whenever they think that there is a legitimate interest, direct mail, and there is a reasonable expectation of getting email in continuation of the first deal, you still need to make sure that that email campaign is really necessary and there's no alternate means to reach out to your client's client. It is something that has been discussed about the GDPR, that there is not clear-cut answer. So you have to just make sure that your client understands that whenever they have to launch an email campaign, they have to ask themselves those questions. And finally, the most important call that the authorities in the EU are going to make if there is a complaint about your client activity regarding marketing, emails, and all that, is to say, well, the number 3 condition, or the number 3 prong, the third prong of that test, is to know if your client's activity, that email, infringes in one way or another on the fundamental rights of privacy of the clients of your client. So yeah, you can say, okay, I made personally the call of saying, yeah, it's my legitimate interest to send some email, and there is a reasonable expectation from my client's client to get this kind of email a few weeks down the line, a few months down the line. But now you have to ask yourself if that email that reached out to your client's client is or is not infringing on the fundamental rights of privacy of this client. So here, I call it in the slide the implied general interest of the data subject. But basically, the people in the EU who are born in countries that usually, like in France, Germany, have in their constitution the right to privacy, expect that in the rest of the world, that right to privacy would be respected. So it is a fundamental right that we don't have here in the US Constitution. And you have to be very careful, because the people that you are going to tell your client they can send email to, or he can send email to, are pretty itchy about the right to privacy. It is a constitutional right. And as such, they have already organized in consumer associations to go after people, comes May 25, who send too many of those emails, who go after I would say, people at once, like massive email. And because of this, you have to be very careful when you tell your client that it's not just the national authorities, it is the complaint that clients can do or users can do to those authorities, plus the possible lawsuits, class actions that are going to arise from GDPR with those major consumer associations in Europe. And they are getting organized because they know that they can make a lot of money by going after big companies like the major players of the Silicon Valley for breach of GDPR. So it's not just, the 2% or 4% of the global turnover. It's how many lawsuits are going to be launched in how many countries against a few number of companies, or maybe many companies, or maybe any possible company, like maybe your client company, when the GDPR starts to apply on May 25th. Or it may not be on May 28th or May 29th, but possibly during the summer. We're going to see consumers association starting to complain first with the authorities about email that their subject have received, and later introduce a lawsuit in Paris, London, Brussels, Stuttgart, and so on. 28 countries where you could have a lawsuit to defend, and that is something I would like to remind you, cost a lot of money for your clients, and to yourself. You cannot go in Europe and fight in all those countries. You would have to hire a local lawyer everywhere. So this is even more important than what the blogs and some media have said, the 4% of the global turnover, that in my personal take, nobody ever going to have that. Maybe they're going to have a couple ones that going to be fined close to that, but then those people with good lawyers, good European lawyers, going to fight back, and for 10 to 15 years, nothing's going to happen. So the thing is very important to understand. When you have fundamental rights to privacy, that opens all kind of lawsuits. And then you would say, yeah, okay, but maybe there has been a breach. Maybe the information of those guys, those clients, has been disseminated on the dark web. And, but at the end of the day, we're going to apply the same standard. And here, has it been a problem for those clients? Do they have harm? Can they prove a harm? Well, the GDPR say, you know what? We don't need harm. We don't need damages. We just need the possibility of harm. We just need this guy to say, hey, look, I've been breached. My data is somewhere on the dark web or wherever, maybe not even on the web, maybe on hard paper. They have my credit card number. I don't know where my credit card number. Well, what I know is that company was careful or not, but ended up being breached, hacked by some hacker from you name them, Russian hacker, North Korean hacker, Chinese hacker, or maybe hackers from the eastern countries or from France. There are good people in France that know how to hack, I'm sure. So then, just because they've been hacked, they could sue for damages without having to prove harm. It's kind of a surprise to a lot of my peers who mention that. But it's the reality of the GDPR. It's one of those little shop of horrors of the GDPR. You can have hundreds of thousands of people suing overnight companies in America without having to prove any harm. Now, my take on that as a lawyer, I'm going to tell you. Okay, they win. Okay, your client gets massive amount of fees to pay in Europe, in several class actions over several countries down the line, 2 or 3 years, 10 years from now. But what? How do you, pay? Why would you pay without having to make sure that the decision that has been obtained over there can be implemented in the U.S.? How do you collect in the U.S.? Well, you would have to go through, I don't want to go into detail here, but you would have to go through some special treaties with each of those countries and make sure that the local national law that has been applied is similar to the American law. And here you would have a problem because you say, hey, in Europe, there is no need for harm. But how can the American judge who's going to consider that judgment before it's executed here, he would just say, well, I have a judgment from the French courts. I respect it. But they don't have the same standard. So I am not going to let that judgment go here in the U.S. And that is the problem that most of the European courts would have, is that their judgment would just be as good as the papers they're written on. Because when you want to get that judgment applied in the U.S., you have to go through a U.S. judge that verifies that the standards that we have here in the U.S., protecting the rights of individuals, is similar, of the same nature, to the one that were applied to get that decision. And they are not because of the non-necessity of harm, when here we have to prove some harm until the Supreme Court maybe one day change that. But so this is important that your client understands that the real issue with GDPR is about looking good. It's not about having to pay some fine down the line that I believe is going to be a long time before they have to pay any fine if they know how to fight it. It's just bad publicity. Think Uber, think Yahoo. Those are the companies that look bad, and they are really with a problem. When Uber goes to Europe and gets all those people in the street, the taxi driver and all that, it didn't help that they got that breach and kept it under the carpet for 1 year. And in the if it were under the GDPR, that would be probably a very hefty fine that would have landed on the desk of their GC. So this is very important that your client understands. GDPR is there to stay for many years. That probably is a directive, maybe even longer. But being compliant with GDPR shows goodwill. shows respect of the consumer's rights, shows respect of the right to privacy, which is in Europe a fundamental right. So this is very important, because every time your client is going to tell you, oh no, come on, again, you're going to say, look, be the good guy. Be the one that's going to advertise on your website, on your literature, everywhere, that you want your client to be protected in terms of privacy, that you do everything possible. And remember, a few weeks ago, Facebook came up and say, look, we're going to be the good guy. We're going to give a lot of access to the European consumer as to their privacy on the website. We're going to give them control over it. And that's true, because they cannot do anything else, but they are going to use that to make it like an advantage, like some plus they're offering. And Google does the same right now. So this is very important that your client gets the thing. The message is GDPR is here to stay. It brings a level of consumers in Europe as to their privacy regarding American use of that privacy so far, which is what you know the problem that we have when we use massively the amount of data and profile people. So we have all those pop-ups when we surf the web, and everything that pops up is kind of profiled to what we like or don't like. So this is basically the message. Yes, you can get fined. The odds of getting fined for most of the people are very, very limited. And if they are, you can dispute those fines in European courts, and it takes forever. But your image in the EU is going to be tainted, because there are very strong consumer groups to fight for the fundamental right of privacy. So, as I said before, GDPR ready or GDPR compliant? Well, this is where the line has to be drawn for your client. He can be ready. He can have the best pop-up, the best, yes, I agree. He can get the link next to it, to the privacy policy. And he can even put a button to undo the consent. He can do a lot to be ready for GDPR. However, he needs to also add what GDPR expects from your client's employees, which is a privacy awareness, kind of like we're doing right now. Having your client train the employees about privacy in general and GDPR, European privacy in particular. He also needs to understand that the data that has been grabbed over the years without control is probably full of errors, and probably has people that maybe don't belong to your business in any way. He also needs to adapt his privacy notices to the GDPR, because he has a reach to the EU one way or another, a footprint in the EU. So it cannot just be the California template or the New York template on privacy. It cannot be copy-paste of a website that to kind of shave a little bit on the lawyer's fees. The privacy notices are important. And as to the individual's rights, we're going to see how your clients need to give them a particular attention when it comes to the right to be forgotten, the right to change, to modify the information, the right to have a copy of whatever is in your client's server, even in the cloud, and the access rights, access requests are important, because whenever a user in the EU is going to request something from your client, you and your client are going to have 1 month to satisfy that request. And finally, the breach. They're all going to get breached. We're all going to be hacked, even in law firms. As you know, many major law firms with great IT guys got hacked this year, and 2017, not yet in 2018. So data breach are here and going to stay for a long time. Now, how do you prepare for it? That's what GDPR expects from your client, to get ready and prepared for when your client's going to get breached. With that, we're going to see the privacy awareness. So here, the training that I do some of that training for my clients or from lawyers and their clients. It is basically what you have, let's say, for harassment. It's a video that's prepared that you can buy here and there, and that you put there, and the clients and the employees have to look at that video, and there's different ways of making sure they do. And then they hear about GDPR. They know what is, the rights of the users in Europe and all that. They spend from 20 minutes to 1 hour, depending on what kind of video you offer, and that's it. It's awareness. It's not knowledge. They're not going to take a PhD in privacy in a French university at any time. So it's just privacy awareness. But the GDPR says that your clients need to do that. It is written in GDPR that they have to get a program to train their people, the employees, in order to get that. So usually when I talk to my clients, and I put together, as a matter of fact, tomorrow I have one training of all the personnel of the company. And I said, would you be kind enough also to bring in the board? Well, people were saying, the board of directors and all the shareholders and all that? Why would I get, the people that are just here every 3 months? Yes, the board, as well as the executive from the CFO, CEO, and all that, the C-suite executive, they must be part of that exercise. They must hear about GDPR. Now, maybe they're going to text a little bit, when the video goes on. Nobody's here to see. But you have to make sure that they sign that sheet at the beginning and at the end, or maybe both, and that you can later document who got that training. This is essential for the GDPR, that people in companies all over the world know about the GDPR. You also have to do your homework for your client and your client regarding the awareness in terms of risks for the company, in terms of where is the data, and this is important that the IT people understand that they can no longer copy data, backup data in the cloud everywhere, and distribute laptops without having any security on it whatsoever. You have to make everyone on board in your client's company aware of the consequences of a breach on the privacy of EU individuals. Maybe the client has only 10% of its turnover coming from Europe, and 90% of the sales is Asia, Australia, of course the US, and South America, and Europe is only 10%. But it doesn't matter, because that 10% can bark and can go after your client, like I said earlier, with consumer organization, complaints to the 28 authorities and all that. So here, if something like that happened, and you cannot show that you had everybody on board regarding privacy awareness, that you didn't do any training, that you didn't put any policies in place internally, that you didn't change confidentiality level of people, that you didn't make sure that the same password and ID were shared by 20 people in the company. If you don't show that, and there has been a breach internally, or it could be a disgruntled employee that kept his password and ID for another 3 months because HR doesn't have an outboarding procedure in place, you would be your client would be under siege by many or several authorities from the EU. And they could not even say, oh, but I had some training, or we had a guy that came and talked to us about GDPR. You have to really make sure your client is ready, has changed the policies, IT policies, so that GDPR gets to be a good evangelized. I mean, that GDPR has been evangelized in a good way in the company. You can run, as to security, what is called tabletop exercise, which is basically simulations, where you have IT guys, HR, communication group, of course the CEOs, CFOs, and now they all can come into a room, and for half an hour to 1 hour, maybe more sometime, because it's fun, they brainstorm a problem. Bob on that morning came and there was an email, he opened it, and then boom, his computer was locked up. And what do you do? And first step, people brainstorm. Do you have to call on the European authority? Yes, no, do you, and so on. And then you go forward. After investigation, in that email, we figure out that it came from the CEO. And so Bob didn't know that the CEO had an attachment that was poisoned. How did it come? And then you come into like, oh, well, it could be this, could be that, and people start to get aware of things. You're not going to ask people, the C-level, as to even the low-level employee or the executive secretary to do some coding of any kind. It's just sitting around the table and, massaging a problem. And this way they get to understand how it works. Then you get the HR, involved because they didn't have an outboarding procedure. So next time they think about it, like, oh my God, we better put in place something that the minute the guy is fired or quits, we just tell IT and we cancel all the access for that person. That is what basically is required by GDPR, is to train the people thoroughly about privacy issues and the risk level in the company for not doing the proper things. So as to knowing your data, this is the first thing I do when I come into a company to evaluate the GDPR readiness and compliance level. It's called basically what we just say in general, the data map. Where are the servers? Where is the data from the EU today? Maybe partly in the EU, maybe in some computers here, maybe remotely, just in the US remotely when you look on the screen, or maybe it's a copy of it into your Salesforce or whatever, the software that you're using, a CRM, customer relationship management software. And then, does it come from the EU or not? Because if it comes from any other country and it has nothing to do with the EU, your client sleeps well. There's no problem, no GDPR here. You can know it right away. And who do you share it with? Well, of course, if you get some data from the EU and it's on such and such and such server, that's one thing. Now, if you start sharing or selling it outside to vendors, that could be another problem. And when I say, sharing it with, you have to think in terms of, okay, do you have any contract with Google, with Amazon, or other provider, Microsoft, on the cloud? What kind of contract do you have? And then you have to imagine, are these people reliable? Well, probably the main brand that I said, yes. But how about the local IT guy that just told you that he offers you for a quarter of the price a cloud that he runs in his closet in his bedroom, and you know that guy is not going to make it with the low price that he asked for you to host all your database on his cloud. So he's also making a buck by reselling all the data to outside companies without telling you. So this is very important that you know who you're dealing with and who you're sharing that data with. You also have to make sure with the data of the EU subject is recorded properly. You have to keep a book, well, electronically, of course. It could be just an Excel spreadsheet, where every time you have a main treatment or processing of the data, you register it. What is it? Well, basically, every time you're going to send a massive amount of email, or every time you're going to make a research, marketing research, or market research from all your clients to find all the girls between 24 and 63 or whatever, every time you do then from that a new action, like maybe a new website for them, well, this would be when it's time to say, I did profile, I did select people from all my data that I have on the EU. This would be a processing issue if you don't record it. You have to record every time you do that kind of activity. And of course, you have to correct any data that's wrong, wrong address, wrong telephone and all that. But most of the time, you will not know until the client, user, customer, who has access, the right of access to verify his consent, tells you there's something wrong in the data. So you have then to make sure that in order to satisfy the requirement from GDPR to have data of good quality, to have data that that reflects the personal information from your client accurately, you would put in place a system where your client can very transparently go on your website and have a login and modify that data. You've seen that, and probably you already have that even in your law firm at some point. Your clients, most of the people have that now, the login system. And you have to give them access. Maybe you're not going to give access to every single field of the database, but everything that is really personal information. So you put procedure in place so that that access exists. The privacy notices are important to your client, but also for you, because once you know what to add to a U.S. privacy notice, I would say, well, then you can spend some hours there. You can, it's also a good approach to your clients, today clients, either litigation or any IP advising or transactional work. You can mention very casually about your privacy notices and the GDPR. And if you know how to do that and what to add, well, that could bring the client to ask for more about GDPR, then more billable hours. You don't have to be super duper certified and having done, like I did, two universities, one in here in Los Angeles, one in France, in Strasbourg actually, to take after my JD what you guys call a LLM, which is a Master 2 in Europe, in France. You don't have that. You need that to draw privacy policy. And then if you have the right information, you can start having new work from clients regarding the GDPR. You also have to include in all the privacy policy, as I said earlier, some special language regarding consent and the use of the personal information. You have to be sure that everything I said before is reflected in the privacy policy that you give to your client. What we said about transparency to the user is basically the very important three requirement that you see on that slide. First of all, you have to tell your clients what you're doing with the data, and you have to be honest with it. You can no longer hide behind, kind of obscure language and very general terms about that for commercial purposes. Like those messages when you wait for 3 hours on the phone and then you hear that, your call is important to us. Yeah, sure, it's been already 35 minutes that I'm waiting and I hear that your call is important to us. Well, you can't do that here anymore regarding privacy notices. You have to explain what you're going to do with the processing, and if you say that you're going to do some marketing because it's part of your business to do marketing with the data, well, you have to state it and making sure that the consent that's given to you to use that data is a consent that is given for that purpose. You have to tell them how long you're going to keep that data alive in your database. You don't have to say how many days. You can say, we retain that data for a year, 6 months. You have to be reasonable. You cannot say for 10 years. But you have to, make a call here, and you're going to get some guidance in the few months. You're going to get the European authorities to publish white papers about it and tell what actually comes out of the GDPR first 6 months of practice, what would be a reasonable average standard time to keep the data on the servers. And this is something that is important that the client sees in the privacy notice. And of course, you have to let them know in the privacy notice that they have the right to complain. And to who? To each European authorities. You're not going to give the list and the email address and a template to complain, that's for sure. But you have to tell them. You have the right to bring to the attention of your national authority of your country any grievance that you have about our use of your personal information. It's clear. They know that, they can hold the gun against you. But at the same time, as I said before, if you do all that, you're going to look like a good guy. Your client will look as a good guy in matter of privacy for those clients. So, in general, as you heard me here, you have to tell your client that he has to respect the privacy rights of EU data subject because it's fundamental rights. Okay, and they have to do that in a way that is crystal clear for the average user, the John Doe of Europe. When he goes to the website, doesn't have to have a master's degree in law and privacy to understand what your client's going to do with his personal data. With this, individual rights of John Doe from the EU are very important to explain to your clients. I'm not going to go into details here because you heard and you read probably a lot about the right to be forgotten and all that stuff. But basically, you have them on the screen. I would comment them very quickly. The right to be informed is what I told you. Inform when the condition of consent have changed. Inform what you're going to do with that consent. The right of access. They want to have access to what you have on them. So give them a login. Give them the possibility to access that data one way or another. The right to rectification, to rectify, to modify what's wrong with that data. Well, they have access. They see something wrong. Well, give them the edit mode rights. And to be forgotten, and the right to be forgotten comes out from the case against Google in Spain. There's a lot of writing about it. It's a new right, I would say. It was not in the directive. It's a right to ask at any given time to withdraw the consent, because it goes with the consent, to withdraw the consent and say, please delete me. I don't want to hear about you anymore. I'm a disgruntled client, or just don't do that anymore. I'm not interested anymore in buying that kind of product. And you don't have to discuss. You get that request. 30 days later, it should be satisfied. It's kind of like the credit report thing, but we haven't seen it applied yet, but probably going to be some software that let you do that. I know that some CRM big companies already offer some modules to keep track of this kind of request on the database. The right to restrict processing. This is a very single little right that maybe some people are going to use. And that right is about how you are using my data automatically, how you are profiling me, how you are making possible to see all those pop-ups, all those ads on the side of my Google search that are just targeting my information. Well, this is something that is new too. The right to restrict processing is the right for someone to say, look, I don't mind you have my name and my email address. You use that for marketing purposes. You send me email once in a while. It's good. It's okay. It's okay. But I don't like when you use my information, you aggregate that information with other people's information and massively sell it to some data analytics company. And all this automated processing, I don't want that. You use my data plain and clear, my email plain and clear, but any kind of profiling, nah, stop it. That's the right to dispute or restrict the processing. Right to data portability, that's a funny one. That's a funny one because in fact the GDPR say, hey, anybody can just write to you and say, give me a copy of my record in a way that is readable. Readable, or it could be Excel, it could be a text file, but then anybody in Europe can ask for a copy of their own data. You imagine if tomorrow morning your clients, let's say, have 100,000 customers in Europe and you get 100,000 people saying, I want to know what you have on your server about me. That would be a little bit of a problem if you don't have some kind of a software to satisfy. Basically, if you have a customer relationship management software, it gets in the request from the website, automatically it's exported in a format, like I say, Excel, text file, and then the client within a few seconds get a clear image, photography of the data you have on him. The right to object is kind of like the right to restrict processing. It's the right to object to the use that you are doing with the data, and especially if you are using protected information. I would say the kind of information that in Europe is suspect, like you have the suspect classification for the First Amendment. It's about the same, race, origin, religion, and all that. Add to this trade union ownership, and that is also part of the right to exclude from profiling and auto decision making artificial intelligence based on those that kind of information that people don't want to be spread. You know, if they belong to such and such political party, if their sexual preferences, all the kind of stuff that you see on some websites that voluntarily you sign up to, John meets Mary and all that. So you have all those meeting websites, and then you give a lot of information because you want to look good, and then you tell all your preference. So it goes way beyond to the kind of book you read or the kind of movie you go see, and then you show basically almost a naked me out there, and you just want that so that you can get a chance to get somebody to meet you that matches your preferences. But you don't want that to be used to receive email or to have pop-ups on your website every 2 minutes that you surf the web or look at an article or something that exactly matches your sexual preferences, or that really matches your political inclination. You don't want to share that. So that is basically the right to exclude automated processing, profiling. You can just say, look, keep everything on me, even my political activities, even my sexual orientation, because I just subscribe to such and such party, so yeah, you have the right to know what I prefer, or I just want to meet other people, so yeah, you have to know my sexual orientation. But I don't want you to use it any other than this, just for that purpose, the original purpose. I don't want you to profile me in any way or to sell my data in any way. This is the right to exclude yourself from all kind of data profiling. So this is basically included, all those rights, in what we say access request. At any given time, any user who consented to your usage of his personal information has the right to make a request to you, as described in the privacy policy, to the email privacy@abc.com. He makes that request to restrict processing or modify some information, and you should do that. Same credit report, same thing, no charge. You cannot say, we'll do the send us $1.50 or whatever. No charge. And you have 1 month, like I said, to comply with the request. And just to be sure that we're between lawyers here, you have a little bit of leeway of exception. You can tell your client, yeah, don't worry. If you get some weirdo that's going to send you a request every day and all that, it would be manifestly excessive. I would write the letter for you, or here's a template. We would not have to answer those requests every time we get them. So here's a list. You can say what you are requesting for the 10th time here is manifestly excessive. We can charge you $100 or $60 or whatever you want, maybe $1 million to get the guy off your back. But at any time you need to explain very clearly why you refuse. You have to do this within the 30 days, and you have the obligation to tell them, look, we have the right to deny your request, but you have the right to fight back that denial of request. You can go to your local authority and explain to them that you made that request 20 times, day after day, just to pester off this company or client's company. But maybe the authority is going to be on your side. But you have to tell them, yeah, you have that right. So when you reply, it's a template that you can use. You say, well, and by the way, if you're not happy with that, please make sure that you complain with your national authority, and who's going to investigate the matter any further. Okay. So then, let's have a little bit more fun, because all these privacy issues, it's not really that fun. Let's talk about breach hacking. That is what really I want to hear, because if there is no hack, there's not much to say about privacy other than the profiling issue and big data analytics companies. If there's no hack, there's no risk to the privacy of your clients. So here, how do you prevent that? The hack actually is at the heart of the GDPR. So what happened is, whenever you have an incident or the client has an incident, he has to go through a few steps to make sure that the right authority is called upon, that the procedure in place let unplug the servers and all that. That is what is in the incident response plan. And if the hack put at risk the fundamental privacy rights of your client, like credit card, financial identity, all that, then you have to write to the DPA, to the Data Protection Authority of each country where you have clients that have been breached. At the same time, the report has to be also made to each individual if the risk is not a normal risk. We can't with every hack to the fundamental rights of privacy, like sensitive information. But if it's also a very high risk to their rights and freedom, then you have to tell them directly that their credit card information has been spread all over the world because you've been hacked, that's the kind of thing. Then, only then, it's both the DPA, the Data Protection Authority, and the users. And yeah, you got 72 hours, but not from the day of the hack, from the day that your client has been aware of the hack. Think again here, Yahoo. Well, they were aware of the hack, a few years after the hack, apparently, in the latest news that I heard of the major Yahoo case. Several tens of millions of people hacked. They didn't realize that for a while. Well, there's another company, the driving company, drive yourself company, that had a hack. Well, they paid the hacker not to reveal anything. And for a year until a new CEO comes on board and everything becomes public. Well, that company, obviously, like I said before, would be on the hook with the GDPR for hiding for over a year a hack that they had 72 hours from discovery, and they obviously had discovered that hack when they paid the hackers, which is probably, I think, within a month of the hack. Then I would like to make sure that your client understand that GDPR is not a whole new set of laws in Europe. It's been around for over 20 years with the directive, the 95 directive, but even before we talk about Europe. Canada in 2000 had a whole set of rules that are very close to GDPR. It came from the OECD Fair Information Practices, where you can read very quickly. In 1980 already, the organization published a white paper where it already stated limited collection, the quality of the information, the purpose of that collection, and limited usage of that collection. All things that are really inside the GDPR. It was there as soon as 1980. So we waited 40 years before we came out with our own set of rules in Europe. Security was already there in 1980. Openness, participation, accountability, all those notions were described in 1980. But Australia in 1988, same thing, you see again, transparency, anonymity, collection, and so on. You have the slide and you can go back to that later on. Canada, as I said, with their act, have introduced actually the consent, as you see on the third line, consent to collect the information. So if you are in this privacy law business as a lawyer for a while, you don't really fear or discover GDPR. It's a natural accomplishment for the EU legislator to have put in one book and 99 articles what has been written for the last 20, 30 years, 40 years in matter of privacy. And you should not, scare your client if you tell them that GDPR is under control, because it's nothing really new under the sun. The 6 data protection principles that we've been talking about is written here. You need to have a mean of collecting that is adequately linked to a purpose. You cannot collect information for no purpose. You cannot just grab the information of people and then say, it sits there and I'll see what I can do with it. It can be limited also in time. You can say that I grab all that, it is with a purpose of marketing whatsoever, but you cannot keep it forever. It can be accurate, of course, as I mentioned, so it's very close to what we've seen with Canada, with Australia, with the OECD. And you keep it just as necessary, and it has to be for something legitimate purpose or with consent. And of course, we talk data breach, security, confidentiality. The sixth step, basically, that you will have to go through with your client is for some to find the data protection officer. I'm going to go and talk about it in a moment. And then you have to create a data map, as I said. That's step number 2. So you find the data protection officer if your client falls into the conditions of having a mandatory data protection officer. This is object of the next few slides. You have then someone in-house to help you, but if not, your client will have to do his own work and find out with the IT people where the data is. Could be on some other servers, could be at Amazon with AWS, could be at Salesforce, could be anywhere on the cloud with Microsoft Azure, could be with Google. Anyway, that data that has been collected from European subject must be somewhere, and you have to find all the different places where it is, because it's very important not to have transborder I would say exporting the data from Europe to the US without having the proper conditions to do that, which you heard, privacy shields, BCR, binding corporate rules. You may have read that. I'm going to say that globally, if your client export data from the EU to the US, there are 3 ways. Either they have a standard contractual clause in place between the people in Europe that export to here. So let's say your contractor, your website in Europe or whatever, whoever runs the show in Europe, they export to you the data, or they let you have an access to it, I mean, through your screens in the US. Well, in that case, both parties, I mean, your client, and the contractor must have in place some standard clause that has been pre-approved by the EU in the contract. Or you have internal clause. It's not a subcontractor, it's a subsidiary. So it's like Facebook US with Facebook Ireland. And then you have a set of internal clause, a contract, between subsidiaries and headquarters, and you submitted that voluntarily to the EU authorities, and after about a year and a half, so it's very long and tedious, they approved your clause, and then you can say, okay, I have a set of rules, BCR, binding corporate rules, that apply to all my subsidiaries all over the world as to European import of data. And then the last one, which is the most known, the famous privacy shield, which is in fact basically an offspring of what was before the safe harbor. It's not safe anymore because a guy, Mr. Shem, who was a law student in Austria, decided to sue for the fact that for sue Google Spain and other lawsuit that followed after that, for the fact that, well, the data that is collected in the US is visible to the national security agencies, the NSA. So as such, any data collected from private individuals in Europe can be looked at by the US government, and thus doesn't pass muster of the directive of 1995 as to privacy. So basically, the European Court of Justice agreed and said, yeah, until then, no export to the US without having the proper check and balances in place. So safe harbor, which was a self-determination of export compliance, you could self-certify yourself. Now you have what is called, well, they found a name, privacy shield, Well, the Privacy Shield has been put in place very quickly. Basically, the only thing that could have worked is to say, okay, no more NSA. Okay, we should down the NSA, and then we can start dealing with Europe. Well, it's not going to happen, right? So Privacy Shield doesn't pass muster, in my opinion, and in the opinion of other people. And as a matter of fact, Mr. Shem has introduced a new lawsuit against Privacy Shield, and it's going to be another probably decision within a couple of years that say Privacy Shield is not that good, and we're going to have another name or another procedure. And GDPR is not really clear about that. It tells you that you have to be compliant to those three different procedures that I mentioned: standard contractual clause, BCR, and Privacy Shield, but it doesn't say exactly what should be what should be done in exporting the data in details. So then you have to realize that all these must be prioritized when you talk with your client. After you know where the data is and where the risk, you have to be sure that your client understands that it cannot do everything at once because there's a cost associated with that. So you prioritize where the highest risk in the highest cost. If you have to transfer all your data from Europe to here, well, maybe here you have to spend some money to get those authorization from Europe and have your internal rules. Or if it's a smaller client, like most of the time you're going to be confronted with this issue of export, is because the client has a local provider of or whatever, and that provider should be agreed in Europe should have the authorization in Europe to export the data to clients in the US. So they would have themselves made self-compliant with the EU, with including in their contract the standard contractual clause has been approved. So when you sign with that provider in Europe, your client signs something that is okay. But then your job as a lawyer for your client is to look at all the contracts with the providers of services in Europe, and on this contract, check that there are all the necessary European clauses that authorize, in one way or another, the export to the Europe, and there's a standard contractual clause used by the EU in such matters. Then you have to manage the risks, which is the organizing the training, let's say tabletop exercise or simulations. It's not really organizing, what you hear in cybersecurity, red team and doing some penetration test of the client's resistance to hack and all that. You can do that. Your client can do that. If you want to have some fun, you can even spend a weekend there. But it's not really that. It's something, be prepared. Have in place all the checks in a book that says, call EU. Send an email to that email address. Who's in charge of doing that? The CEO, the CFO, whoever. Put that in a book. It's called the Incident Response Plan or Breach Response Plan or whatever you want to call it. But that book has to be in place, has to be prepared, has to be reviewed by each department head and their personnel. Staff must be aware of it. And of course, if you have some, let's say, communication, external agency, they have to be part of that plan because they must know what to do when there's a breach, to communicate and say, well, we've been breached. Houston, we have a problem. So here it's very important that the incident response plan is a group work, something that is done by the departments. And you as an external counsel, you can lead that exercise, even if they have to hire a special IT company, anti-hack company, whatever. You're the special counsel on that. You have the attorney-client privilege. If there's anything that you see during that period that was a risk or has been identified as super-duper risk, and later there's a breach at your client, they cannot get that information because, yes, you were aware of it, you went and remediate, so, remedial measures and all that. And you also had the work product of all your notes, and you also have your attorney-client privilege. I know a bit because as a French lawyer registered with the California Bar as a foreign legal consultant, I can only deal with EU law and advise you today and my clients, but I am under attorney-client privilege. Just as you, I have to abide by the French canons of ethics and by the California canons of ethics. But I could not do that in New York because I'm not a FLC in New York. So I'm very aware of the differences between work product, attorney-client privilege, and all that. And I would say it's very good that as a lawyer, you get involved in anything breach, anything that's related to secure the data of your client. And as an external counsel, but you won't have to put your hands into the dirt of computers and all that. You just have to monitor, advise, be aware of what's going on, participate to those meetings, and at the end of the day, review the plan that they would put. This 20 to 30 pages book that have all the procedures in place. And finally, when your client has done his homework in terms of risk, you have to make sure that internally they organize all the processes, the pop-up for the agreement, they register the consent in some kind of a file, the trans-border transfers there are checks and balances in place as to the rights of the users, and the request can be made and all that. So this is something that's important for the client to do in the 6th step of compliance. And of course, they have to document all those operations, put it in writing, reports, email, whatever. But put all that in a big book. I usually put a binder. I go to a client, and after 1 or 2 weeks of work with their team, day after day, I put in binder the contracts, I put the data map, I put all that in a binder. And then when I leave the client, I ask them to keep that binder alive. Every time there is an addition to a contract, every time they see something that we didn't cover, then they put someone to work on it, and then they add to the binder. At the end of the day, the binder after a few months is going to be 3 or 4 or 5 binders, but if there is a breach, they can show the authorities in Europe by scanning the appropriate page or by sending them an electronic version of that binder, that they have done their homework, that they are the good guys, that they should not be fined, that maybe they're going to have a little slap on the hand because they missed something, but that's it. They're not going to get any of those big fines, and they're not going to have to worry about being sued by consumer and losing to the lawsuits. They're going to be fine, because even if they show to the authorities, to a judge, that all have been done by the book like it should be, because they respect the privacy rights or privacy fundamental rights of EU users, they're going to be good. So document compliance, to document anything compliance with GDPR is really key, because it makes them defensible in case of problem with the authorities or the consumers or consumer associations. So now the data protection officer. Basically, the data protection officer has been set in the GDPR as a new requirement. It's a new job. It doesn't exist. It did exist in Germany. Germany had some data protection officers under the directive. But for most of the people in the world, the data protection officer isn't a job, but it's just a privacy counsel. Basically, it's either internal or external. If it's internal, it should not be the general counsel or 1 or 2 privacy. You take a privacy counsel who knows about privacy, and you say, now you're going to be the DPO. You can say you're going to be privacy counsel and DPO, or you can say you are the IT manager and DPO, because there are conflicts of interest, and you cannot have conflict of interest. So when that DPO is in place, it's going to take care of mapping the data, like I said before. It's going to help everyone discuss, meet, and find ways to secure the data. It's going to prioritize the action that I said before with a budget. And by the way, he must have his own budget, because he must be and remain independent. That's the GDPR. It's a good job. You cannot be fired for doing your job. It's to protect it like a whistleblower, basically. So the DPO, which I do, I've been DPO already in Europe, because we had the equivalent of a DPO in France, because the French authority has required French companies or a certain size on that to have a DPO. But the DPO basically comes in a company and is the guardian of all things privacy, and it is going to help the company or your client grow, and is an internal DPO. It can be external. In other words, it can be like, I can be hired your DPO or the DPO of your client on a full-time basis or part-time basis. In other words, it can be shared with other companies. So there's different things. When I say I, means the DPO that is coming from outside can be, not just me. I'm not the only one that can do that. So the DPO is key in that sense that it is a protector of privacy, and is also the one that's going to communicate officially with the authorities instead of the or the CEO or the CFO, which limits the risk of saying things that you don't want to, say out loud. The DPO manages all the risk, and with the IT team, but is not involved in controlling the hacking process and all that. I mean, the protection against hacking. He can say, yeah, you should have such and such software, but he's not the one that is going to implement. He just has a say to it. He organizes all the processes of checking all the rights of the users. So basically, if you have a DPO in-house, it makes everything easier for the lawyer, for you, for major companies. And if you don't, you can always tell your client, look, pick a guy in your company and call him DPO. And you write to the authorities, 20 authorities in Europe, that you have named Bob the DPO of your company. Maybe the guy was IT manager, maybe he was a privacy counsel, maybe he was just somebody that loves privacy, and he got to get the right training, of course. But he can be your DPO. There is something that is expected from him is to know all about privacy law. He can take a certification with the IAPP or any other association as you wish that has a reliable certification system in privacy law. But you can name anyone a DPO. It doesn't have to be a lawyer. It doesn't have to be a CPA or an expert in whatever privacy law that you want. He has to know privacy law in Europe. And finally, that DPO is going to organize all your documents that prove your compliance. So in other words, the best defensibility for a client is to say, here are my documents, here's how I recorded all the processes, recorded all the consent of everybody, and this is the key. Because the data protection officer, I'm going to go back to here, data protection officer is going to be, in fact, the key person, the point of contact for the authorities, so might as well he knows everything about privacy in your company. So now, a few words before we close about the SME, the small and medium enterprise and the startups. Probably most of your clients are going to fall in that category. You have to add, you have to add what is known as privacy by default. But basically, you have to tell those companies or your clients, set up everything in your website, in your contract, by default to protect the privacy of your client. It's by default. It's not opt-in already checked. It's not, if you're not happy, just opt out. By default, everything must be chosen by the client, by your clients. This means, of course, that if you have a new product, like a startup, everything privacy must be conceived at the very beginning by design. And if you want to add another layer of security, then you would make sure that all the databases, all the hard drive where the databases are encrypted, so that if it's encrypted and there is a breach, nobody can read any name of any kind, so there is no breach of privacy possible. There's much, much more to say about encryption, but basically Article 32 doesn't say you must be encrypted in GDPR. It says one of the means of protecting the data is encryption. That means, well, you've been alerted that encryption would please the authorities. If they see that, they would say, well, then that's okay. You've been breached, but it's encrypted, so we're good. And last word about what you heard, blockchain, all that. Blockchain, the problem with blockchain is it's permanent. You cannot alter blockchain information, as you know, because like they use it to register financial information. So here, how do you delete information from a blockchain? I would not recommend that. Basically, we've seen through that AdTech and MarTech. I don't know if you see very well here, but you don't have to read. This is to say how AdTech and MarTech, marketing advertising companies, are going to be affected by GDPR. Look how many companies are on what we call the LumaScape. You can Google LumaScape and you have it in big. It's all those companies that deal with profiling and all that. Nobody really knows how it's going to affect. So the day after, and I'm going to close on that last minute, happy Friday. Yeah, May 25th, like I said, it's a Friday. Relax. Nothing's going to happen. Your client is going to go to jail or find 4% of their turnover. I'm saying that because people think, well, maybe I'm on the list. Yeah, if you have big fishes, yeah, they're going to be on the list, on their list, even if it's not official. I'm sure that they have 2 years at different authorities in Europe to prepare, so they're going to send out a few letters. But medium-sized companies, small companies, I don't think they're going to be the first one to get those request letters. And still, you have time to answer and all that, but you have to get your clients ready with the right processes in place. Like I said before, if they need a DPO, it has been named already, and then comes the letter from any authority. They can show that they were prepared thanks to you, and they'll be off the hook. Remember to say again that EU consumers, today nobody has sued anybody because it's not part of it, but as soon as the GDPR comes into effect, watch for consumer groups to start suing American companies. And last word, well, as I say, GDPR is just a beginning. Every national law can add to it. So be aware that if you have your client and you're 100% compliant, in the future you can keep that client happy when you tell him that in Germany now there is some addition to GDPR that just passed as a new law, and they have to be compliant, then you can work the problem with that. Well, thank you very much. I can take questions eventually. Oh, there is a question here. So I'm going to read the question. It's a jurisdiction question, incidental contacts with the EU. U.S. banking client with only U.S. customers. A U.S. customer travels to Europe for vacation and accesses her banking information via 1, mobile phone app to check the account and pay bills. 2, uses an ATM to withdraw money while in Europe. In your opinion, does the U.S. bank need to comply with GDPR? Does it matter for the U.S. bank if the ATM withdrawal collects data from Europe? So first, if it's the mobile app and the data is here and it's the U.S. data and it resides here at the bank in the U.S., there's the only thing in Europe is that you set foot in Europe physically, but that doesn't make the data collected in any way in Europe, doesn't make your data being European origin, so you're fine. ATM, well, that is different because, in fact, even though we have networks, you know, Visa and all that, and I would say chances are that all the ATM networks in Europe are already prepared for GDPR, either under standard contractual clause between banks or binding corporate rules. This would need to be checked. I don't have this kind of client right now to give you an answer as to are they ready. My 5 cents, most, I would say probably networks like Visa, they have a very strong privacy team in the US, so I guess they're already ready over there. Visa, MasterCard, American Express, they must have something in place so that whenever you try to withdraw at the ATM or at the American Express office, the data that is collected automatically is GDPR compliant, and I don't think the American bank or American Express US would be in trouble for letting this kind of transaction happen to a US customer happening to be in Europe.